Assalamualaikum warahmatullahi wabarakatuh, and good day to everyone. We have seen Malaysian legal system here in terms of legal history of Malaysia. So now we move on to the next one, which is sources of law, and we're going to start off with unwritten law first. Now, when we're looking at unwritten law, before we move on further, we need to look into English law first. So, for this topic, today at the end of this lesson, okay, you should be able to categorize the different types of sources of law and explain the application of English law. Now, when we talk about sources of law, we need to know or identify what are the sources of law. Okay, in terms of sources, there are three main sources of law, which is the historical sources, legal sources, and places where the law can be found. Now, when we talk about historical sources, we talk about religious belief, legal customs, and opinion of jurists. Okay, we have seen that. And then when we talk about legal rules, when we talk about legal sources, we need to talk about legal rules that makes up the law. Okay, this we're going to discuss later. And as far as sources is concerned, we also need to know about the places where the law can be found. So you can find law in statutes, law reports, previous decision of the courts, and textbooks. Yeah. So these are where does it comes from. Now, if we look at these sources of law, is divided into written law and unwritten law. We're going to start off with unwritten law first over here, where unwritten law is further divided into English law, which we're going to do today, and case law, judicial precedent, or what we call doctrine of stare decisis. And the next one is customary law and Islamic and Sharia law. Okay. And then after we have seen is unwritten law, we're going to look into written law, which is federal constitution, state constitution, legislation, and subsidiary legislation. Okay, now we're going to start off first with unwritten law. Okay, unwritten law is the laws, this is the law that not enacted by legislature, which is the parliament and the state assemblies, and which also not found in constitution, both federal and state. So basically unwritten law comprised of these four things, which I've already explained earlier. Okay, we have seen that the English law was introduced through the Royal Charter of Justice, and there are about 3 Royal Charter of Justice. And then we know that at that time, British officers has no knowledge other than old law. So that's why they actually brought in the English law into the Malay states. And then we see later that the British government set up courts with their own judges, which eventually spread the use of English law in the states of Malaysia. Okay. At that time, English law is unwritten law because of its origin and its largely unenacted laws. And so it's scattered. The law is basically based on common law. So English law comprises of the following, which is common law, rules of equity, statutes of general application. So what is common law? Common law is, as I've already explained earlier, is made up of local custom of the local people, of the English people. So this custom was used throughout the country, to which the term common law is derived. So they are distinct from local custom from our own people, and the purpose is to standardize the law so as to make it uniform and equally applicable to the whole country. The common law was brought by these English people, and it was further developed by the courts when the judges made decision on particular matter. So decision given by the judges become a guideline and precedent. So precedent is something that you set and it will be followed later. So basically, the decision given by the judges will become guideline and precedents, and when they're going to use it when the similar issue arise later. Okay, the second composition of the English law is rule of equity. Okay, what does it mean by rule of equity? Yeah. So equity means fair or just in wider sense, but its legal meaning is the rule developed to mitigate the severity of common law. So basically, they find that there are some common law decision very severe, and they think that there's no justice. So basically, this equity was developed to mitigate, to reduce the harshness of common law. So equity was administered by the Lord Chancellor, who was not bound by any common law technicality. So basically, the Lord Chancellor will decide whether it is fair, okay, and whether both parties, are not losing anything. So he decide cases based on conscience and fair dealing. So it was developed out of the need to provide the plaintiff with relief where the strict common law rules granted as an unsatisfactory or there was no remedy at all. So as a result, equity give better relief and was more just compared to the common law. So it is actually most of the time when they find it there's no just, so they will look into a rule of equity. Now, what happened when the common law and equity conflicts? Both common law and the rule of equities continue to develop, but somehow or other there will be time where the two will be conflicted. So what will happen? This will resolve by decree of the king, where the common law and when there's actually there was conflict between common law and equity. Equity prevails. Why? Because equity means fairness. So this sort of conflict between common law and equity will prevail. This approach will continue until today. Now, but then in order for you to use equity, one is what are the things that you need to have fulfilled first. Now, there are some prerequisites in order to obtain equitable relief. So he who comes to equity must come with clean hands. You must not have done anything wrong. And then because equity is equality, so equity will follows the law. Okay, and then if you think that you want to have judgment, you should not delay, especially when when you did nothing wrong. So if you delay, you defeats equity. So basically, you yourself must come with clean hands, and you should not also delay. Now the other one, when we talk about equity, we have talked about common law, we have talked about rules of equity, and the other part of English law is what we call statutes of general application. So what does it mean by statutes of general application? It means that those British Acts of Parliament which were applicable to the people at large in England. Okay, and then basically if a statute applied to the whole act or substantial part of it, and not merely a few provisions. So basically, when we talk about statutes of general application, meaning the whole of the statute will be applied here. That is what meant by statutes of general application. Now, first and foremost, we look into English law. Now, English law, we know that the history, how it comes about to West Malaysia, how it comes about to Sabah, and later Sarawak. Okay, and it still continue until today because the government could not abolish English law straight away, and at that time, because there was no other immediate alternative. And then later, when our parliament come up with all those acts, we can now refer to our own. But then we also need to know to what extent the application of English law in Malaysia is governed. How is applicable? So it is governed by Civil Law Act 1956, particularly Section 3 and Section 5. This is how, to what extent English law is applicable. So English law was formally received through legislation of 3 statutes. So the first one was Civil Law Ordinance 1956 for Peninsular Malaysia, and application of Laws Ordinance 1951 for Sabah, and then application of Law Ordinance 1949 for Sarawak. We can see that Sarawak apply the English law much earlier. Even we have seen it when we did our legal history. So now all these three ordinances have been combined or incorporated into Civil Law Act 1956. And then there are two provisions which is very important in the Civil Law Act, which prescribe the application of English law, which is Section 3 and Section 5. Okay, so what is Section 3? Section 3 talks about the the part where the court is required to apply to apply the English law. Okay, we look at Section 3 subsection 1 paragraph A, where the court is required to apply in West Malaysia or any part thereof the common law of England and the rule of equity as administered in England. So you can use those law as of until 7th of April 1956. Okay, same thing in Sabah, the common law of England and rules of equity, and together with Statute of General Application. So there's three things which can be applied in Sabah, and those laws are relevant and enforced in England as of until 1st December 1951. What it means is that whatever law that was administered and enforced in England until 1951, 1st December 1951, we can use it in Sabah. Okay, just now, whatever law enforced in England, whatever law until 7th of April can be used in West Malaysia. Okay, so but then for West Malaysia, we only talk about common law and equity, but in Sabah, common law, equity and statute of general application. So Sabah situation is similar to Sarawak, but then the Sarawak can apply the common law of England, rule of equity and statute of general application as administered or enforced in England until 12th of December 1949. So whatever law that is enforced in England until 1949 is applicable in Sarawak. And then the types of law that is applicable are the common law, rules of equity and statute of general application. Okay, so it's best to know that those dates, 7 April, 1st December and 12th December, all those days are actually what we call cut-off date. So after the cut-off date, English law does not become law in Malaysia now. But then we see that the common law of the statute of general application is only applicable for Sabah and Sarawak. So that there is an issue whether it's also applicable in West Malaysia. So in the case of Mokhtar Arimugam, the court refused to apply the relief provided by the English law because of Section 3 of the Civil Law Act 1956. Same thing in the case of Pemodalan Plantation Sdn Bhd and Rachuta Sdn Bhd, the court held that the defense of legal sad-off, which was based on English statute, did not apply in West Malaysia. Why? Because of Section 3 of the Civil Law Ordinance, which says that only common law and common law and equity is only applicable in West Malaysia. So you cannot use that status of general application.